thank you for joining us for another episode of God, Law, and Liberty with David Fowler, President of the Family Action Council of Tennessee. Every week, we are putting culture, politics, and law on a collision course with the truth of God's Word. And now, here's David.
Well, I'm glad you have joined me for today's episode of God, Law, and Liberty, and I think we're going to have a quite interesting, informative, and educational program today, because this week on October 15th, amicus briefs, which are colloquially known as friend of the court briefs, were filed in the United States Supreme Court in a case that I think is of civilization defining importance. And we're going to talk about some of those briefs today. But quite literally, the whole of the Western legal tradition is on the scales of justice. And we'll find out next June, probably June 30th, what will become of this case. And I wrote in my commentary last Friday, and if you'd like a copy of it, you can email me or go to the website factennessee.org, and under commentaries you'll find it. But I wrote that it's the most significant case of human meaning, of anthropological weight, since the court's 1857 decision in Scott versus Sanford, where the court said slaves and descendants of slaves were not U.S. citizens under the Constitution, because at that time they were considered, quote, a subordinate and inferior class of beings. And this case will establish for potentially decades to come what it means to be human. And it comes out of Tennessee, interestingly, although there are multiple states that have passed statutes like the one I'm going to describe. The case that got to the court is from Tennessee. And it's focused on whether a Tennessee statute prohibiting medical interventions, not counseling, but medical interventions for minors suffering from an incongruity between their bodies and their subjective experiences related to gender, is constitutional. And the Department of Justice has intervened in this lawsuit against the state of Tennessee on the ground that the state law that prohibits these medical interventions for these minor children violates the 14th Amendment's Equal Protection Clause. And on the department's theory, there is a discriminatory classification problem. And this idea of discriminatory classifications is really a made-up, non-historical interpretation of that clause. But anyway, that's an issue for another day. In the department's words, this law is a problem because, and I quote here, put simply, an adolescent assigned female at birth cannot receive puberty blockers or testosterone to live as a male. But an adolescent assigned male at birth can. Now, if that sounds confusing, it took me a while to get into what all this transgender stuff is saying and who's what, but to put it in woke terminology, the department is saying all persons are gendered. And of course, we would agree with that. But what they're saying is they're either cisgendered, meaning their bodies and their subjective understandings of themselves harmonize, or they're transgendered, meaning the two don't harmonize. I guess they could also be non-binary, saying we're neither transgendered nor cisgendered. But the department is saying this law is bad because it allows drugs that affect hormonal development to be prescribed to one kind of person, a cisgendered person, and not to another transgendered person. That's supposedly the denial of equal protection. And I filed an amicus brief that among the 48 that were filed, that I think is unique. And it built on the ones that Jeff Schaefer and I put together and filed in the Sixth Circuit in the Federal District Court. And the argument is simple, but to appreciate it and to appreciate the really disconcerting brief filed by an organization with an esteemed scholarly reputation, the Ethics and Public Policy Center, EPPC. And that's what I want to focus on today, really, so that you can see that even good people, even Christians, advocate for a return to the Enlightenment. And so that you can appreciate the difference between the brief that I filed and the one that EPC filed. Let me just read to you what the Equal Protection Clause of the 14th Amendment says. It's very simple. No state shall deny to any person within its jurisdiction the equal protection of the laws. Of course, the key word for interpreting that sentence would be the word person, which I think grammatically we'd call it the direct object of the verb. Anyway, that persons is key. If you don't know what a person is in the law, then you don't know who gets the protection of the law, right? You don't know to whom it applies. Yet, from my reading of the argument summaries in all 47 of those briefs, only one, the one that I made or filed, made a legal argument directed to the legal meaning of that word. And I took the importance of that word in the law all the way back to Justinian in the 6th century with the Justinian Digest and the Justinian Institute. And he wrote, this is in the 500s, in his digest, quote, "Since all law is made for the sake of human beings, we should speak first of the status of persons." So see, he's equating human beings and persons. Persons are human beings are persons. In his Institutes, he wrote, quote, "Knowledge of law amounts to little if it overlooks the persons for whose sake the law is made." So being able to know what a person is fundamentally important. And as we'll see, the Ethics and Public Policy Center, the PPC, focused on the meaning of the word person, to their credit. But it's the way in which they advocated for its meaning that really distressed me, that I think you need to appreciate and understand, because the argument, it may be more fancy, but it's not much different from what we see most of the time being made by Christians. And I think it's important to understand that brief to see how easy it is we can conform to the thinking of the world and perhaps not realize it. And to be honest, with persons like Carl Trueman and Andrew Walker, among its scholars, I would hope that they would not lend their credibility to this brief as a legal argument. Now, they didn't sign the brief. They weren't named in the brief, but that's part of their organization, and I would hope they'd say, no, that's not the kind of argument I would make. Perhaps you'll understand why I say that as I go through the rest of today's episode. But anyway, back to the case. What the department is trying to do is to have the Supreme Court inject into the word person a new understanding of what it means to be human. One that, in my opinion, finishes what Roe with abortion and Obergefell with marriage started, namely the elimination from our law, from our jurisprudence, of objective physical states of being and their procreative nature as relevant to law and society. So, to touch on my brief quickly, by way of comparison to the EPPC brief later, here are a few nuggets of what I wrote. Quote, "The contest in this case thus raises questions as to whether there is a human nature, whether male and female are objective conditions of identity that state law may recognize." In other words, is there such a thing, a real thing as male and female, that that states can recognize. That's what they are. So we're going to make the law around those prototypes, you might say. And I also wrote this, and I think this is very important. The concept of health itself vanishes from the law's apprehension of health if it can no longer recognize a pre-existing and given human nature by which conformity to or deviation from wholeness and integrity can be judged. In other words, if we're just lumps of matter, lumps of cells that have no given meaning or purpose, no telos, then we can arrange them any way we want to, as long as it doesn't create, medical complications, health complications, right? So in order to know what's healthcare, for healthcare to even be objective, we have to know what it means to be human, so that removing a young woman's breast buds would never constitute health care if we have a given nature, a part of which is its procreative capacity. But if that's not essential to who we are, if it's an accident of nature, just so happen some are male and some are female, well, then, those things really aren't that important. And of course, you can see this whole issue of procreation is greatly diminished already through the abortion decision, and even the reversal of Dobbs left it open to say, that's just state by state decision as to whether being a woman and being in a maternal state is anything of significance, an objective reality the state should recognize. And of course, Obergefell versus Hodges is the institutionalization of sterilization in a marital relationship. So what I'm saying is this is not a case about what medical experts think are appropriate medical treatments for minors who suffer a break between their minds and their emotions and their bodies, which we know as Christians to be a consequence of sin in the world. But it's really a case about what it means to be human. And that's why I said this is a civilization-defining case. Whatever that word means, according to our court, come next June, that will drive the soteriology and eschatology in our law. What is salvation? Salvation will be being able to change my body parts to become something new, and that will help me achieve my telos or my end, right? And in time, our society will embrace that, because what it means to be human goes back to our cosmology for us that we find in Genesis 1 and 2. So remember, these three always go together, and cosmology provides the foundation for reason in relation to soteriology and eschatology. So on this matter of anthropological meaning, I rooted the meaning of the word person in the context in which it's being presented, not in a pulpit or a Bible study, but in a legal context, in the common law. And I traced the common law understanding that we are male and female, and that's the two categories of being that the law has always recognized, and the right of those beings, male and female, at common law to, quote, their life, limbs, body, health, and reputation. So essentially, what I said is that it's been the law for centuries, before there was even statutes and equal protection clauses, that no third person, not even a physician, can injure the natural functions of a person's body. In other words, we don't have to have a statute to make medical malpractice a wrong. It is a wrong already. Statutes only codify what the law already was. And we said that if you change that, if you change this understanding of persons, then all the categories of law, as they developed over the centuries around these prototypes, they will be upended. Paternity law, for instance, right now is being upended. Parental rights laws, as we've known them, as we understand those rights, well, they're gone. I fought with Alliance Defending Freedom over that in the last legislative session, and our Tennessee legislators, we have to understand that until these issues of human meaning are resolved, we don't know what we're passing into statute. And how it's going to be interpreted. That's water under the bridge, I guess you could say. But I hope you can see why this has the potential to be civilization defining. Now, I could go on, but that should be enough for you to appreciate the contrasting kinds of arguments made in the brief by the EPPC. Oh, and if you would like a copy of my brief, shoot me an email. Send it to, and notice this is a different email address, Senator Fowler 94@gmail.com. Senator Fowler 94@gmail.com. And might want to hang on to that because that'll be my address as of January 1st if you want to reach me thereafter. But anyway, turning to the EPPC's brief, here is how it described itself to the court. EPPC is a nonprofit research institution applying the Judeo-Christian moral tradition to critical issues of public policy, law, culture, and politics. In pursuit of its mission, EPPC equips Americans to address today's ethical, political, and cultural questions with firm commitment to human dignity, natural law, and our constitutional freedoms. Okay, so we need to appreciate that it's the Judeo-Christian moral tradition. Okay, and look, I don't really have great problems with that term because the Judeo tradition, as we would take it from the Mosaic polity, as we would take it from Genesis 1:1, the law written on the heart, and it would be, of course, embedded in, and Christian moral tradition goes beyond those negative commands to all the positive commands, to loving the Lord our God with all of our heart and our neighbor as ourselves. But oftentimes those are used as code words for saying we don't really want to get into religion too much. We don't want to get into revelation. We just want to talk about history or natural law. And I think I've mentioned on this show before that there are two understandings of natural law, the old one and the new one. And the new one comes from Hobbes and Locke and Rousseau and all those kinds of guys, and it is not Christian, and you need to make sure you're being very clear what kind of natural law that you're talking about. There's a classical version that would include the antiquities, Cicero's Republic, for example, as well as Christianity. And then there's the more modern version that would be the Locke, Hobbes, and those guys. So anyway, that's the kind of organization that they are, and I want to give them kudos for this statement in their brief because it accords with what I was saying in my brief. And here it is: the fundamental disagreements between the parties are not rooted in different assessments of the scientific evidence as much as they are in fundamentally different visions of what a human person is. Now, I didn't root my argument at all in anything about scientific evidence. If you're made to be reproductive of a male, then to remove your gonads is, I don't need any scientific evidence to show it's harmful. It just is per se. But anyway, they're still correct. They're fundamentally different visions of what a human person is. And they go on in the next sentence to say the United States disagreement with the state of Tennessee is rooted in the fundamentally moral question over how best to care for children experiencing distress over their sexual identities. I agree there. It is a fundamental moral question. The two sides offer different answers to this moral question because they approach it with radically different visions of the human person. Well, I wouldn't disagree with any of those statements. But then they go off to make an argument based on really the philosophy of the Enlightenment, which was decidedly not Christian, and its metaphysical and cosmological vacuousness led to its collapse and brought us to the place of nihilism that we now live in. But let me move on and I'll come back to that. So here's what they say in the brief. Here are the two visions of the human person. Quote, the first vision, call it the traditional vision, holds that a boy is a boy, a girl is a girl, and neither feelings and desires nor drugs and surgery can change this immutable genetic truth. The second vision, call it the transgender vision, holds that we all have sex assigned at birth, which usually corresponds to our physical traits, but which may or may not correspond to our inwardly felt and outwardly expressed gender identity. The transgender vision holds that a person's gender identity is a constitutive part of his or her humanity, and that when a person's biological sex and gender identity diverge, often gender identity should be given priority. It's more true, I guess you could say, to the essence of what we really are. Now, here's the key to the argument for why the court should allow Tennessee to embrace the traditional vision. Quote, this view, the traditional view, is supported by science and experience and known through reason. Now, I want to come back to this matter of epistemology, what we can know simply through reason. But I want to bring this to your attention as well. Another important difference between this kind of argument in this brief and the one that I filed. No argument is made that the word person in the Equal Protection Clause rejects, as a matter of law, the second division, the transgender vision. In fact, the last sentence in the EPPC's argument is this, quote, these matters of the traditional vision and the transgender vision, these matters and the state's judgment reflected in Senate Bill 1 are properly left to the political process. Oh, that sentence hurt me. Because in other words, the EPPC would keep the argument for the transgender vision alive. And it's just saying that some states can choose the one and not the other, which means children in some states will continue to be mutilated. It's like, well, some people, I guess, in some states will be citizens if they're descended from slaves, but in other states, well, they can't be United States citizens because they're insubordinate and inferior beings. I mean, this is Dred Scott on a even more fundamental level. We don't have any human nature. There's no insubordinate or inferior at all. We're just all lumps of cells waiting to be rearranged to suit our subjective understandings of who we are, and that should be decided by democratic processes from state to state. Now, this is not get a half a loaf if you can't get the whole loaf kind of argument the EPC is making. I don't think this is what, Doug Wilson, he'd have to speak for himself. I don't think this is what he'd call smash mouth incrementalism. But rather, it's arguing that the Constitution lets you choose the loaf you want. And no moral judgment can really be cast on those who choose the transgender vision. Just different demographic, right? I mean, I'm not sure how else I could read or understand that last sentence in the argument portion of their brief. And I don't think, to be honest, Carl Truman would concede that point, or Andrew Walker. But the organization they're associated with and esteemed by seems to me to have done so. And that's not my vision of Christianity. And I'm not saying theirs isn't the same as mine, but that's why I couldn't have signed that brief. Because what the EPPC called a fundamentally moral question can be answered whatever way is democratically decided from state to state. And no, my Christian vision is clear. This is wrong in every state. And a right interpretation of the word person in the 14th Amendment, if we will make it, as a matter of law, says no state shall. And that's what I think the law ought to be. But anyway, now coming back to the point, about what can be known by reason alone, as I looked at the authorities for relying on reason cited in the brief, it was the works of Plato and Aristotle, in an argument on the Thomistic view of the one and the many. But of course, Thomas Aquinas was the one who was trying to square Catholic theology with Aristotle. So I would read the EPC's brief as urging the courts to let the states that want to go back to the good old bad days of the 18th century Enlightenment do so. But of course, that 18th century Enlightenment was built on the antiquities and undermined Christianity at every turn. That's why I called it the bad good old days. I mean, yes, if we at least had the heavenly city of the 18th century philosophers, it'd be better than the hellish cities we have now. But that heavenly city collapsed into the hellish ones we have now. So I've spoken in this in the past, referencing the excellent and honest assessment by the noted 20th century historian atheist Carl Becker. It's in his book, The Heavenly City of the 18th Century Philosophies. And if you've not read it and you want to know why we're washing nihilism today, and you want to know why a return to this Enlightenment kind of philosophy is bound to fail over time, you need to read the book. It's not long. It's not full of big words. But let me give you one quote from the book that I think will help you understand why Becker and those who think like him, who are in our positions of influence, will have no problem brushing off the EPPC's brief as nonsense and irrelevant to anything, much less to law. This is a court of law that we're in, not a philosophy class. So anyway, here's what Becker wrote. In the early 19th century, so history, he says, could still be regarded as the transcendent idea. That's what Plato had, right? That there's something transcendent, there's something beyond. And it was realizing itself in the actual. Becker continues, but in our time, history is nothing but history, the notation of what has occurred, just as it happened. As history gradually replaced theology, so science has replaced philosophy. In other words, as you'll see, Becker is saying to the EPPC and those who think like them, don't come into the modern man's courtroom and tell us there's anything to learn from history other than the facts themselves. And especially don't come messing it up with your philosophy, no matter how ancient, because your amorphous, undefined metaphysics can't support reasoning, only nihilism. And yet, it seems to me, that's precisely all the ECCP offers. It's a history lesson in philosophy. And I want to come back to that next week, because it's so important with an examination of some of the things Guillaume Groen van Prinsterer wrote in his book, Unbelief and Revolution, and some things Cornelius Van Til wrote in response to Derrida and about nihilism, that I think it will make more clear why this kind of argument will achieve nothing long term. And I think they'd be calling out this kind of argument too, but in ways beyond my ability, which is why I'm going to share some of the things that they wrote. So I hope you'll come back next week as we look further at how good people, even Christians, can not only conform to the thinking of the world, but not even be addressing the current thinking of the world in a way that will have purchase in the sphere of law as it stands today. This is a legal argument that needs to be met with legal arguments and legal reasoning. And we'll look more at that next week on God, Law, and Liberty.
If you enjoyed this episode, please subscribe to the podcast. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. God, Law, and Liberty is available on Apple Podcasts, Spotify, and wherever you listen to podcasts. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram at Fact Tennessee.